So, hi everyone, and welcome to the Immigration ABCs podcast. I am your host, Dustin Saldarriaga. I'm a senior associate at Scott Legal PC in New York City. And today we are very fortunate to have Ian Scott joining us once again. For those of you who have joined us in the past, Ian was on our podcast before. Ian started our firm a decade ago. He has personally navigated a number of visa options, including the H-1B, F-1, TN, and now the E-2. Our firm was started on an E-2. And so we wanted to sit down with Ian and really talk about this question of how the business immigration landscape looks different today compared to 1 year ago. And of course, the big event that happened over the last year is the re-election of Donald Trump and the policies of the Trump administration, which has had a significant impact on immigration across the board, including business immigration. So we wanted to have Ian back on to share his perspective, both as an owner of an immigration firm, as well as someone who himself holds a visa and who has to navigate the process of renewing his visa, of entering and exiting the U.S. as a visa holder. So we do thank you all for taking the time to join us today. With that, Ian, welcome to the show. Thank you for taking the time to join us. To kick us off, in very broad terms, how would you say that the practice of business immigration has changed over the last year?
Great. Thank you very much, Dustin. It is great to be here. And I think that the question is a fantastic one because there has been quite a bit that has changed. So I think that if I had to summarize the change, I would say that the business immigration world, when you're applying for a visa, you have to really be prepared and really make sure that you're pulling together documentation that is accurate, that is persuasive, and also that you are looking back at your prior immigration history and making sure that there aren't any blemishes or marks on that immigration history. And if there are any, that you're dealing with them, because in the past, sometimes we've seen that these things may not come up or they may not be an area of focus, because I'm not talking about things that would make one inadmissible. I'm talking about things that would not make someone inadmissible. That means that they're still able to get the visa, but even those things are causing problems when people are submitting visa applications. So I think that one of the big changes, I think we always wanted to put together applications that were correct, accurate, persuasive, but I think that there's even more of a focus on that now. I'd say that that's one category of change. I think another category of change is really conservative advice that we give to clients now. And the reason for that conservative advice is because we do feel that when a client leaves the United States or when they're making an immigration filing, that we have to explain all of the different risks associated with that. Just one example. In the past, when a client applied for filed an I-485 petition, and normally we would just explain to the client that you're in a period of authorized stay, and if you can apply for work authorization and advanced parole, and once you get the advanced parole, you could travel. And we, in the past, really wouldn't give clients any particular warning related to traveling on advanced parole. But now we do. Now we say that we don't say that you can't travel, but we do say that really the ability to re-enter the United States, it's actually discretionary. It's not like having the government can always decide not to admit you, but it is discretionary. So if you have, just to go back to the example that I used earlier, if you had some blemish in your immigration history, even if it's a blemish that would not necessarily make you inadmissible, you could run into the situation where you left the United States and then you attempted to re-enter and then they wouldn't admit you. So I think that, and I think that as we I'm sure that there'll be many instances where throughout the podcast where I give more examples that support the I'd say the different type of advice that we give now versus a year ago, and you know that advice is just much more conservative, I think.
And can you give an example of what a blemish would be that doesn't necessarily make someone inadmissible versus something that would make someone inadmissible?
Yeah, absolutely. So for example, someone that has a DUI, a DUI, driving under the influence, that doesn't make someone inadmissible in the sense that you can still go to the consulate, you could apply for a visa, you could explain that you had the DUI, you might have to do some additional things. But let's say a DUI that happened 15, 20 years ago, you really wouldn't have to do anything other than explain that to the consulate because it doesn't make you inadmissible. Versus something like someone who has a cocaine possession, which if there are a whole list of things that make someone inadmissible, and it doesn't mean that they can't enter the United States, but what it means is that in order to enter the United States, they would require a waiver. But it's a good distinction because the things that I'm talking about are things that that don't make someone inadmissible. But even with those, we see sometimes issues. And I think another good example is that there was a situation that happened this year with students and students who were in the United States. And let's just go through a fact pattern. A student was, in the United States. They went to their consulate. They obtained an F visa. They disclosed on their application that they maybe had some criminal incident, even though, and we're not, this could be an example of where they weren't even convicted, right? So they were just arrested for something, but you're still required to disclose that in the app in your DS-160 application when you apply for an F1. But then there was a period of time, and this has been walked back quite a bit since, but there was a period of time where the government looked at a database and said that anyone with any student that's here that has just been arrested, that they're going to revoke their ability to be a student here, right? And kind of deal with it later. And as I said, that's been walked back somewhat, but I think that those types of things weren't really things that we would have seen a year ago. So.
And with students, one of the topics that came up a lot is social media postings as well. And
Absolutely.
I think that's another example where a social media post is typically not going to make you inadmissible, but in this day and age can certainly cause you issues at the consulate, at a minimum, potentially additional questioning, if not administrative processing, additional security screening. Ian, I want to take a step back because, and maybe wearing your hat as a business owner, I think a lot of what we're talking about in this episode is going to prompt consternation, a little bit of fear in people, because the fact is that the environment is in general more difficult to navigate today than it was a year ago. But I think the thing I want to ask you about is the approvals. And I know, being an attorney at your firm, that we have had, first of all, we see approvals regularly, and we have seen approvals on cases that would have been challenging a year ago. So I think it is important to acknowledge and emphasize that even though there is additional scrutiny in general, cases are still being approved. And I think one thing you said about taking a conservative approach and just being thoughtful, is important to get someone on the path to an approval, which again is happening with some frequency. So I don't know if you wanted to add anything to that about kind of the more optimistic side of what's happening in immigration today.
No, I think that you summarized it well. I think that, I would say that, let me just pick a visa type just because it's the one that I'm on is E2, picking E2 visas. We haven't seen a change in approval rates for E2 visas. So I think that exactly what you're saying is correct, accurate. I think that what we do tend to do when we're putting together an E2 visa file is we may focus on different things, right? So we may now focus on, even though the regulations explicitly say that the investment can be made outside of the United States, we may encourage clients to make sure that a large part of their investment has been made in the United States. So there are things that we have modified with respect to how it is we submit applications. But I think overall, we haven't seen a big change in the approval rates in applications. And I'd say that that's both from the perspective of the consular work that we do and the USCIS work that we do.
Perfect. So while we're on the topic of E2s, E2s are I would say, Ian, correct me if I'm wrong, the visa that we handle most frequently at our firm. Let's get a little bit more into detail on that. You mentioned investment and how one of the changes is we might recommend that someone spend the bulk of their money inside the US versus outside the US. What other aspects of E2 visa applications do you see or do you advise a little bit differently on today versus a year ago? One I'm guessing we would is marginality. I know buy American, hire American was an issue in the first administration. Do you see and do you advise differently on any of the other requirements, including the requirement that the business employ U.S. workers?
Yeah, I think that the answer is yes. I think that more has always been better for E2s. Putting your best foot forward has always been our motto with respect to E2 visas. But I think that's even more the case now. So cases where the person has invested a low amount of money, I think we would encourage them to invest in more. I think that certainly with employees, with renewals and for even initial applications, whether it's the business plan or actual employees that they have, I think that we would maybe increase that or try to get the client to increase the number of employees that they plan on hiring, because I think that more is definitely better. And some of the other things, like what I mentioned with respect to where it is that you spend the money, I think that that is like things like that. I think are going to be very important for making sure that the case, increasing your chances that the case will be a successful one.
Mm-hmm. Um, we file E2 applications around the world, consulates around the world. We also file E2 change of status applications and extension applications within the US through USCIS. Have you seen, again, over the last year, certain consular posts or USCIS ramping up its scrutiny beyond what others are? Are there any consulates or USCIS that are really taking a tougher approach versus the others?
Sure. So let me start with USCIS and just give you an example from a consultation that I had recently. So this was an applicant who initially obtained their visa. It was quite some time ago. I think it was 13 years ago. They obtained their visa at a US consulate abroad. And then they came to the United States, and then they visa was issued for 5 years. They were here for 5 years. And then every 2 years after that, they filed a USCIS petition extending. And so the applicant, this was 13 years ago, so the applicant filed several petitions successfully. However, the last petition that they filed, which was adjudicated a couple months ago,
Mm.
the USCIS came back and asked questions about their criminal background. Now, this particular client, when they initially applied for the visa, they disclosed their criminal background, and the visa, and they applied for a waiver, and they were approved. After that, they kept on filing extensions, and the extensions were being approved. But a few months ago, they filed an extension, and the government came back and asked about their past criminal activity. Well, actually, no. First, the government came back and they said, come in and do biometrics, right? Which normally aren't required,
Mm.
right? So then the person came in and did the biometrics, did their fingerprints, et cetera. And then the government sent another notice saying, we want you to send in all of your criminal history from your home country and also anything in the United States. And what was clear when we went through his criminal history in the UK, that he just that alone, because maybe I'll just focus on that alone. That's easier, because the way that it works is when you have to apply for a waiver, the waiver would have, in this case, would have been granted for 5 years. Now, really, the extensions that he obtained after that 5-year period, they shouldn't have been granted because USCIS actually isn't permitted to extend when you don't have a valid waiver. But for several years, that extension was approved. But this year, I said to him, I said that even if we ignore anything that's happened since you've been in the United States and we just look back to what happened in your home country, there's no basis for an approval here. Now, the point of this whole thing is that now today, USCIS is actually going and looking at things like that and raising them, right? Where I think a year ago that, because certainly 2 years ago, he filed that same petition and it was approved, right? So I think that USCIS is raising things like that. I think at consulates, I haven't really seen a significant difference. I think with E2s, there are always consulates that are better than others, right? So there are some consulates that know E2s really well and understand E2s and are extremely predictable. And then there are some consulates, unfortunately, that are not, right? So they are not predictable. And I think that is the same. I think it depends where you go, but I really haven't seen a significant change with respect to consulates, and both in terms of adjudication outcomes and timing. I think consulates that were taking a long time before continue to take a long time a year ago, continue to take a long time, and consulates that are quite quick are, have not slowed down at all. And that I think actually is very positive, because I think that one of the overriding things that I do believe that we'll see more and more, in particular with USCIS, is delays just because of the changes, right? So because I think that if you just getting at kind of another big change that has occurred within the last year. A year ago, employment-based business green card applications, I-485 applications, did not require an interview. So a few months ago, we filed an employment-based I-485 for a successful EB-1A, extraordinary ability applicant. And shortly after we did the filing, the original I-140 was approved, and we filed the I-485. And maybe a couple of months after we filed the I-485, we got our first request for an interview. It's the first one that we've had in years, right? So now, what's the impact of that, right? The person went to the interview, the petition was approved, the I-485 was approved, the person, I believe, even has their green card now. That's all good, right? And it was quick, that was quick. But what's the impact on an agency if all of a sudden, where interviews were regularly waived before, and now you have a slew of interviews, and staff are not increasing, they're decreasing, right? Because we had the changes with respect to agencies reducing staff, and that USCIS, that affected USCIS as well. So I do think that we are going to start to see significant delays at USCIS, and I think that we haven't seen it yet with respect to timing at consulates, but State Department changes could impact the timing of adjudications as well.
Yes. Right. So this idea of gumming up the system and not just making it more difficult to be approved, but to even proceed through the steps is definitely something that we've seen. If we one of the real values of what our firm does is, if we just expand the scope from the E2, is we will sit down with clients, talk to them about what their ultimate goals are. And so when someone comes to us, we may explore other visa options, both non-immigrant options. Let's stick with entrepreneurs. We may look at the O1. We may look at the L1 for intracompany transfers. If their goal is to permanently stay in the U.S., we might look at the EB-1A that you just mentioned, or the national interest waiver. How, over the last year, how, if at all, has your approach to looking at those other options changed? And I think specifically, if someone is in full compliance with the law, meaning that their intention when they come in on a non-immigrant visa is to depart, but if they may ultimately change their mind and want to pursue a green card, how does your guidance change in terms of how they navigate that process? And just to kind of simplify the question, when you look at other non-immigrant options, how does the E2 weigh compared to, say, the O1, the L1? And is that different over the last year? And if they want to pursue a green card, does navigating that process look different from how it did a year ago?
Yeah, no, I think it's a great question. I think that the difference has to do with the explanation related to the pros and cons of leaving the US, right? If you're in a situation where let's say you're in the United States and you want to change to an L1, or if you're in the United States and you're deciding between going back to your home consulate or doing a change of status, or you're in the United States and you are deciding between getting a green card and doing consular processing, or doing I-485 and applying for advanced parole and work authorization. I think that the focus now, while there haven't been substantive changes with respect to adjudication trends yet, I think that the focus is on making sure that the person understands those risks. If they do decide to, like, so I'll give you a good example. We have a client that came to us recently, and the client applied for EB-1A with another law firm, and they also filed the I-485 petition, but they received an RFE on the EB-1A.
Mm.
Now they came to us to assist with answering the RFE, the request for evidence on the EB-1A, and we're kind of going through, well, what are your options? Can you apply for an O1 now? And the O1 would require that the person leaves the United States and then re-enters on the O, maybe gets the visa. I think this person's Canadian, so they could re-enter on the O, but would have to leave the United States and do that. Do we want to file another EB1 I-140 application and try and use the existing I-485? Sometimes what happens, this is getting a little legally complex, but what happens is that sometimes you're in a situation where there's a remedy. So let's say that a person is in the United States and they want to file for an employment-based green card, and there's a regulation that says that if they're in the United States out of status for up to 6 months, they can still file for that employment-based green card. Now, in the past, I would not have had any hesitation utilizing that. It's called 245K. But
Mm.
it is like many other immigration benefits, a discretionary benefit. So what I do find is during consultations and meetings with existing clients, I think what I end up doing is spending a large part of my time explaining to clients exactly what the implications of the various choices or options that exist. Because I think at the end of the day, it is, they're the ones that have to make the decision, and we can recommend and we can explain. But I think that with some of the changes that we've seen, some of the things that we took for granted a year ago, even though they were by law discretionary, we would have regularly taken advantage of those. But I think now we're in the position where we do actually have to explain to clients that this is exactly what could happen if you decide to do this. And some clients are risk averse, some clients not so much. So I think that explanation sometimes can be helpful. Along with the recommendation, we're always happy to make a recommendation, but we just wanted to make sure that the clients have all of the relevant information.
Hmm. And one of the green card options that has been in the news a lot is the EB-5, and of
Mhm.
course we help clients navigate the EB-5. There was news of the gold card. Two questions for you. The first is, how has the EB-5 landscape changed, if at all, over the last year? Is it still something that you recommend with the same frequency as you would have a year ago for those who want to pursue a green card? And how has the gold card, what we know about it, if anything, which I know isn't much, how has that changed the landscape and your
Perfect. Yeah.
recommendations?
Perfect. So I think the gold card is an easy one. So
Yeah.
that doesn't exist and likely will not exist. I think the green card EB-5 program is an extremely lucrative program with a very strong lobby group that would, I think, be very upset if that particular visa category was taken away. So I think that that's not going to change. I think that one of the in terms of timing for EB-5, similar, no big changes. But the problem is it's a lot of time. It can take 4 or 5 years to adjudicate an EB-5 application. I think that one big change with EB-5 has to do with what we talked about before related to advice and discretionary benefits. So what can happen now is an individual can file an EB-5 petition, the I-526, that might take 4 or 5 years to be approved. But if they're in the United States, they can file an I-485 petition and they're in a period of authorized stay. But when you look at the actual regulations for period of authorized stay, it actually is discretionary. Right? So, and the same thing where the person can apply for advanced parole or work authorization. But what we're seeing is that in some instances where the individual has some blemish on their, in their past, that the government may be exercising the ability to not grant that discretion, right? So I think that that's something that we have seen, and there was a memo recently that was circulated, and it had to do with EB-5 petitions, but even at our firm, we took that memo very, very seriously. We asked all staff to read it very, very closely so that they could properly advise on clients, because I think that it's the same type of thing where the advice that you give to a client, you want to make sure that they know their options and that they're, exactly what their stay means in the United States.
Perfect. Well, Ian, we let's start wrapping up. I do want to ask you one question for our listeners.
Sure.
What is one takeaway? If you had to say one thing you'd want to leave them with, we always ask this question,
Yeah.
but I think in the context of the last year, what is one takeaway you'd want to leave them with?
Yeah, I think that the one takeaway, and I might do two, but the one takeaway is to not be afraid, right? Like I am on an E2 myself, and I've entered the United States multiple times, and I don't, in all honesty, I don't experience a lot of anxiety when I enter the United States. That's one thing. Don't be afraid. If you have no issues, then it's very as many the highly publicized things in the news. In many of those cases, the person did have an issue, right? There was some issue that the government was addressing. So don't be afraid. But then the other thing is to be more prepared when you're exiting and entering the United States. So in the past, we wouldn't have advised people on a TN or E2 visa to bring anything other than their visa stamp or their visa. When I entered the United States in the past on an E2, I would just have my visa and my passport, and I wouldn't bring anything else to the United States. But I think now that when TN holders, or these are just examples, but when TN holders or E2 visa holders enter the United States, it is a good idea to walk with maybe your TN letter, maybe some pay stubs to show that you're still employed at the company. And those are just examples, but we do see more questions at the border where the government is trying to validate that the person is maintaining their status and things like that. So the one takeaway I'd say is just to be prepared when you enter the United States.
Mm-hmm. Prepare for the worst and hope for the best.
Exactly.
Well, Ian, thank you so much for joining us. To our audience, as always, thank you. Please subscribe, leave a review, share this podcast with anyone who might be thinking about building a business in the U.S. In the meantime, stay well and have a great day.
Perfect. Thank you very much, Dustin. Okay. Thank you all. Bye-bye.
Bye-bye.